Robert. I appreciate the opportunity and thank you all for attending. I know the question that I get, and I know the other judges in the division get most often, is about upcoming jury trials, and I'm going to address that. But I've just got a couple of other things that I've been asked to cover, and it'll only take a minute. So if you could bear with me, at the Chief Judge's request, he's asked me to announce to everybody, if you're not already aware of it, that we're expecting some construction. It will be coming along in December. On top of everything else that's going on, or not going on in the courthouse, we're going to have HVAC repairs, and it's going to cause some significant disruptions in the courthouse. I don't know that it's going to affect the daily practice of those who practice in the law division, because we're doing everything, virtually everything, by Zoom. But I just have been asked to let you know that beginning on December 10th, which is a Thursday, through the following week and ending on Wednesday, December 16th, we're in the western half. The western half of the building will be closed. There will be no heat or air circulation. So our secretarial staff won't be here. The judges will be working remotely, probably from home. And we will have one judge and one secretary set up in the Chancery Division to handle emergencies and what have you. The following week, which I think is the 17th to the 23rd, the reverse will happen. The east side of the building will be closed, and we'll be having a chancery judge and a chancery secretary over here for the same purposes, for emergencies and what have you. Again, I don't think it's going to impact the daily status calls. I don't think it's going to impact the motion, hearings on motions that are contested motions that are set 9:30 and 10 o'clock. Where it will have an impact if there's anybody needs to see secretarial staff and things like that, that gets tricky. And we have been doing some bench trials during this time. Those will not be taking place during those 2 weeks. But again, the chief asked me to make sure everybody's aware. Hopefully the impact to all of you will be minimal.
Hey, Bob, one thing to be aware of on that too is some of you submit paper orders via email the day before. I know most of you use electronic orders, but for those who use paper orders that week, we are not going to have access to emails and printers, so those are not going to work. And we'll talk about electronic orders, I think, in a little while.
Yeah.
But be aware we can't do paper orders that week.
I'm as good a time as any to go into it. I have been strongly encouraging the attorneys on my call to use electronic orders. I've been asking the judges in the division to do the same. It may be a little bit of a little tricky or what have you. I'm told it's not that complicated. I mean, my experience with it is it's pretty straightforward. But I am urging everyone to use electronic orders. That week is an example. We've been through this when we were shut down and working remotely months ago. Getting electronic orders signed, if the judge isn't in here, the judge that's here has to contact that judge, make sure that's the order reflects what the judge wanted. And we have to get it entered, get it physically down to the clerk's office. In electronic orders, it happens in a snap. So during that week, paper orders become virtually impossible. And I don't want to talk too much about it because I don't know what's going to happen. In the event that we were to shut down again and have to work from home, we're going to have to insist on electronic orders. We haven't mandated them yet, but if you haven't done it, please take a look at it. It's fairly straightforward. And my assistant Kimberly's here, and every email has the instructions. So if you get an email from our division, the secretaries in our division, take a look at it. The instructions are on there. I'd urge you to consider using them. It becomes helpful, and I would expect sometime in the not too distant future, they may become mandatory in our division as well. So with that, just a couple of other things. I've asked the Secretary of Staff if there's anything that we can pass along because things are a little hectic with this pandemic. Just a couple of things. These are small, but as you probably know, the judges all have a public email address. The secretaries have their own email address. The secretaries have asked me if I could ask everyone, either send it to the judge or the secretary, not to both. They both wind up in the secretary's inbox, and so they get however many emails they get a day. If you do it to both, it's doubling, and they have to go through them all. So if you could just pick one or the other, it would be helpful. Electronic orders we talked about. One other thing, when we're doing electronic orders, we've had this problem, and I've talked to the clerk's office. My IT skills are virtually non-existent, so you'll forgive me not being able to explain why this is. But if you send me an order the day before the case is on the call, it pops up on my list of orders to sign, and it gets signed in the ordinary course. If you send me an order electronically a week in advance, I don't know that it's out there. It doesn't get signed. So if you're going to send an order because you have an agreement to continue next week's status date, it's very helpful if you let our assistants know before you submit it. We can take care of it. We'll put it on the call for tomorrow. You submit it this afternoon. It'll show up on my call for tomorrow, and I'll sign it. But if you submit something more than a day in advance and you don't let us know, Unfortunately, nothing happens on that. I'm trying to work with the clerk's office to resolve that problem, but so far been unsuccessful. We're still working on it. So the bottom line is if you need an order entered more than a day in advance of the court date, please let us know and we can work it out.
Hey, Bob, on electronic orders, there was an emailed question too that we should just cover real quick too.
Go ahead.
But the question is, if we upload an agreed order to e-access just prior to the court call, should we send an email to alert the court, or is just uploading it the day before the status call sufficient?
If it's on the call, no email is necessary. If it's not on the call, then we would need a heads up.
Right. And you guys should know that on our call sheets in the morning, we have a queue for all the cases for the day. And if there's an electronic order submitted by you attorneys, it will show up on our court call in the morning when we come in, and we can access it and sign it. So as long as you've submitted it the day before, you should be okay on that, or the morning of.
As long as it is on the call tomorrow. Again, if you submit it, it's not on the call until, if you submitted one Tuesday afternoon, it's not on the call till Friday, we may never see it if you don't tell us. And again, it's a glitch we're trying to work out, but until we do, that's the deal. Is there anything else from administration you wanted to address? All right, then one other thing before we get into jury trials, and that is with everything going on with the pandemic, we've gotten arbitration hearings going again. We've been doing some of them in person and some of them remotely, but after a great deal of discussion, the decision's been made by the chief judge that we're going to go, for the time being and for the foreseeable future, exclusively via Zoom on arbitration hearings. My understanding is that's going to begin November 17th. An administrative order has been put out to that effect. But I want to make sure everybody is aware that from beginning the 17th and until further notice, there will be no in-person arbitration hearings. One other thing that I did want to talk about before we get to jury trials, with the emails that you get out of our division, not only are there instructions for e-orders attached, but we also have the roster attached to those. Is that right? We have a roster of people?
Yes.
Okay.
All the judges. And
just so everybody's aware, I expect a fair amount of change around here in the next few weeks. Judge Douglas has taken over in courtroom 2018, the arbitration call. As most of you, I'm sure, are aware, Judge Popejoy is going to be leaving us to head over to the chief judge's office. He's going to be replaced. I don't know who that's going to be just now. And much to my chagrin, he's taking my assistant, Kimberly, with him to the chief judge's office. So there will be a replacement there. We'll keep that posted on these emails. But there will be some changes around here, and we'll do our best to keep you posted as those positions get filled. Now, jury trials. Again, the question I get all the time is when a jury trial is going to begin. Under the current administrative order, they're to begin in our division on January 1st. So I've got jury trials set right away. That first Monday is the 4th, and there's at least one jury, I know, in my call on the 4th, and they're scattered throughout the month. Whether or not, I know people have asked me, is this going to go with the numbers going up? As of right now, the administrative order is in place, and we're prepared to start conducting jury trials on January 4th. Just should tell you that we're also been working long and hard, that if the phone call came this afternoon and said we're shutting down for a month or whatever because of the pandemic, we're ready to work remotely as well. And I don't know what's going to happen from day to day. We just take it one at a time. In the meantime, we are ready to go. And unless somebody tells us otherwise, we're going to be prepared to start picking jury trials on January 4th. And to that end, what we've done is I've met repeatedly with the judges in the law division. We have some, if we're going in January, we have some issues we need to work out. Our county has done a couple of jury trials in the criminal field. We haven't done any civil ones. But if we start going in January, some of the concerns that we have and just logistical concerns is bringing hundreds of people into the jury commission. We select juries in the civil division on Monday, and on Tuesday they bring hundreds more people in to pick criminal trials. The social distancing, this causes problems, and having courtrooms that are large enough to accommodate things like that are all things we've been working out. To that end, and I'll be happy to answer any questions, what we've decided is for the month of January, as long as we're still on a goal for jury trials, our division is going to do one a week. We have right now, we believe, 2 courtrooms that could accommodate a 12-person jury. The courtroom in which I sit, and then the 2018 courtroom can accommodate a 12-person jury, socially distant. So we have 2 spots to do that. But until we work out some of these problems, like just simple things like when a 12-person jury with an alternate 2 needs to take a midday break, just use the facilities. Logistically, that gets a little tricky. These jury rooms are really not designed to be socially distant, and we're working through all those things. But for the time being, the determinations made, we're going to do one at a time. It really doesn't pose a problem the first few weeks because we only have a couple of set, but beginning January, I forget that Monday's the 24th or
25th, 25th, I think, yeah.
we have a number of juries set, and when we look into February, we have more and more sets. So right now, with 12-person juries, we have 2 courtrooms, the courthouse. We're in the process of constructing a 3rd courtroom on a 3rd floor that's designed to be for the use of the law division. It's specifically designed to be compliant with social distancing requirements and has the ability to have multiple parties in that courtroom still being socially distant. Room for if you have a 3 or 4 party trial, we should be able to accommodate that. That will be done presumably, or the projection is February 1st. Once that happens, we'd have that available to us as well. So what we have to do is now, and even if in the future we have 3, 4 cases set for trial and only a few courtrooms in which to do them, we're going to have to prioritize which cases are going to go and which cases are not going to go. And so we've started in January. I've convened a committee, and the committee is the judges assigned to the law division to make a determination as to which case is going to go. And after much discussion, you could do it any number of ways, which is the oldest case, things like that. But I'm of the opinion, and I think the consensus was that just looking at the date of filing isn't the way to manage these limited resources. So we're going to take a look at, yes, the age of the case, but we're going to look at the number of times the case has been previously set for trial, the number of parties and attorneys involved in the case, the number of out-of-state witnesses scheduled to testify, the number of experts, the dollar amount in controversy, the age and the health of the parties, the length of the trial. And no one factor is going to be determinative, but we're going to talk about it. We've made a determination of the 3 cases set on the 24th or 5th. I don't forget what you just told me already, Dave, but we're going to order them 1, 2, 3. And our position at this point in time, until the chief tells us otherwise, if you're number 1, we're going to be ready to go, and we're going to ask you to be ready to go. If there's a statutory basis to continue it, you can make that, and on down the line. And we'll just take it one at a time from there. We're going to meet soon and start weeding through our February cases where we have multiple cases set on a given day. But that's the plan right now. Dave, is there anything about that committee or how we're trying to?
Well, yeah, one thing I should point out too, for those of you that try cases, our goal is to try to get at least 60 days notice to all of you so you can know if you're a 1 or a 2 or a 3 or a 4 and plan accordingly. We're not hoping to do this the eve of trial, so you're caught not being able to go. We'd like to give you as much notice as possible so that you can address any problems that you have. So our goal is to try to meet weekly, take a look at the trial 60 days down, and get emails out to the attorneys explaining what the situation is going to be. Go ahead.
Well, I think that's a great point. And I don't know if there's any questions. I wish that we could do this live and people could ask the questions in real time. But go ahead, Dave. Are you able to see questions? I cannot.
I am. I can see questions. One of them is about social distancing, and the question is, besides separating, what other protective measures are being done? I'm going to let Judge Kleeman answer this because he's had a couple of bench trials, and you can tell the participants what we're doing.
Right. I've done a couple of bench trials, and when there are trials in progress, there's a much that can be done to keep these rooms clean every night. They actually have a robot that does ultraviolet light or something that comes in. It apparently kills COVID, Ebola, and whatever. But we try to do that every time. And what I did in my courtroom, I had a bench trial just recently is, and again, I don't want to tell each judge how to do it, but I would imagine every judge is going to do something similar, is that when you sit in the courtroom, I've had the parties, the clients sit in the gallery. I let the attorneys sit at the counsel table. I rearranged my room so that they were socially distant. I told the attorneys, if you or your partner want to sit next to each other, you figure it out. But there's tables there. If they want to be distant, but the tables were socially distant. The witness would testify. I did require the witness to remove his or her mask during their testimony. I put the podium in a room that was more than 10 feet away from everybody else. And I permitted the attorney examining the witness to take their mask off. But if their mask was off, they had to either be at their podium or at their counsel table. If you wanted to move anywhere else, you had to put a mask on. I don't know if there's anything else I covered, but that's how we did it. We just had it set up. And I normally don't like to tell attorneys you're anchored to the podium, but if you have your mask off, I did make that requirement. For instance, if somebody wanted to approach the witness to hand them another exhibit, everybody masked up, you hand them what you want, go back to your podium, take your mask off and resume questioning. I think that's the best way to go. That's what we did. I don't know if that answers the question, but
well, I should also point out along those lines too, is we are going to see, I think, a lot more electronic participation by both witnesses and by documents. For example, if you have your documents all stored on an iPod or iPad rather than hand the witness documents, we're going to anticipate, I think they're going to be putting screens at the various tables so that we can all follow along. And certainly we're going to try to have the ability to have witnesses appear remotely as well.
Yeah, and that's a great point. If you do have one of these trials, to the extent you can, I know many of you do routinely anyways, but having the exhibits up there so they don't have to constantly be going back and forth, I think is very helpful for everybody's comfort and the level of feeling safe that their people aren't constantly walking up and getting in their space. And to that point too, we take a look at it. I had a professional negligence case bench trial go weeks ago, and I had an expert witness testify from North Carolina via Zoom. And I haven't had a chance. I haven't spoken to the participants, but from my chair, it worked pretty darn well. So, I mean, if the parties wanted to do that, that's something else that can be done to Dave's point as well.
Bob, one more point along the jury timing that was typed in here. If a number one setting finishes in 1 or 2 days, will you start a number two setting that same week when the first trial concludes?
It's highly unlikely. And the reason I say that is because we're talking to the jury commission about trying to figure out how many people they can have in there. And what I've asked for is I need to have the number of people I need to pick one jury in January. And I'm hoping to do 2 at a time in February and going forward. Again, this can all change tomorrow if the numbers continue to go the way they're going and the health department, whatever, says we need to stop it. But if assuming we're bringing new jurors in on Wednesday is not likely. It's all we can do to get the jurors we need on Monday, and to be bringing more people in the courthouse on Wednesday is not going to happen. So I don't think that we're going to have available jurors to start picking a new jury on Wednesday, unfortunately. And pre-pandemic, the answer would have been yes, but I don't think we're bringing any more people in than we feel we have to. And right now I expect that to be Monday and Tuesday only.
All right, another question in the same area. The question is, are we going to be doing remote jury selection? And I'm not sure if everyone's aware, but the Supreme Court has put out some guidelines about that. Bob, go ahead and talk about remote.
Yeah, I've got it here. I think this is it. It's MR 30370. And there's more that talks about it there. If you go to the Supreme Court website, but they, in keeping with the need to get jury selection down, as I understand this, they've authorized the use of remote jury selection. And there are jurisdictions around the country that are doing this. I got to be honest with you. I got this last week. Boy, God bless the folks that got this done by picking a jury remotely. I just see a whole list of problems. But having said that, and I said this to somebody the other day, if you'd have told me a year ago I'd be conducting my entire call contested motions via Zoom, I'd have laughed at you. And here we are. Things are going well. So we have to take a look at this. The Supreme Court's asked us to. We're going to take a look at it and talk about it. I think it would require a fair amount of planning, not the least of which would be sending out surveys to these folks, getting information back. I mean, setting up some ground rules. I have to give this some thought. But again, the Supreme Court's, as far as I'm concerned, has told us we're okay with this. You need to take a look at it because we need to get jury trials going. So we'll take a look at it. I want to sit down with everybody in here and try to figure out the best way to go. And as always, we always welcome input from you, the practitioners. If you have any thoughts about this, we'd be happy to take a look at it. But we are going to have to start getting to work and seeing if this is something we could make go.
All right. Also on that topic is, what has been the experience with jurors coming in for criminal cases? Have those cases been using remote jury selection? The answer to that is there have been several up there, and they've not been using remote jury selection. They've had people come in live, and we've been told by the felony judges that it's actually working quite well. They're getting very few people that are backing out of jury participation because of COVID. Bob, if you want to add anything.
Oh, and the other thing too is the Chief Judge's office and the jury commission is wisely taking surveys of the jurors afterwards that are targeted towards COVID. And the overwhelming response has been positive. People feel comfortable. They feel like social distancing has been observed. So it's been a positive experience. We have had very few people try to get out of it. And it's not just criminal juries, in the conventional sense, but they've been picking grand juries as well, as I understand it. And so far, everything's gone well. I don't know how that's going to go going forward, but for those reasons, until somebody tells us otherwise, we're planning on going forward in January. One other thing Kimberly pointed out, somebody asked about safety measures. And if you don't know, and we start doing trials, because many of you don't come to the courthouse, understandably, for various reasons, is they have this technology, I think it's at airports and stuff too. When you walk into the courthouse, I don't know how it works, but they take your temperature coming in. So anybody with a temperature, I think it's 100.4 or higher, will be denied admittance. Do you
There's
have any?
also a question about trial procedure with jurors, Bob. Will jurors be required to wear their masks throughout the trial?
This is the only question I don't have an answer to. Is I would tell them they will be required to wear a mask. Is during jury selection, would we ask them to take it off? And I haven't really hammered this down. This is a question that has come up, and I haven't followed up on it. In my mind, as long as it could be done safely, I would be inclined to ask them to take their masks off when they're being asked questions, so that the lawyers and I can all make adequate observations, not unlike that of a witness. As long as it can be done safely. Might that require some spacing accommodations and things like that? It might, but that would be my initial reaction. I have not done a jury during a pandemic yet, so I don't know that I have a great answer. I don't know, Dave, if you have any thoughts along those lines, but I think I'd be inclined to ask them to take it off when they're answering questions.
Well, certainly in the new courtroom, the anticipation would be the jurors may be far enough apart where we can do that. In the current courtrooms, it would require having some of the jurors sit out in the gallery, especially in your courtroom. They have to be 6 feet apart if they're not going to have masks on. So that's going to have to be an issue, and it could be a problem.
Right. So, I mean, during the trial, my inclination would be they should wear a mask. I think I would require them to wear a mask. If the only question I would have is during the selection process, when they're being asked questions, I'd be inclined to direct them to take it off during that period of time, as long as everybody could be distant.
I got a ton of questions up here, but go ahead.
No, that's it. I did want to just tell, I guess that's everything I had on my notes, but the one thing I didn't want to tell everybody, and I get the same shrugging of the shoulders, and I completely understand it, but we are doing bench trials. If anybody has a bench trial, they think they can resolve their case that way, we are doing those. And if anybody said they're willing to do a 6-person jury, we can do those far, far more easily than a 12-person jury, for reasons that I think are probably obvious. Again, whenever I suggest that, I kind of get a shrug of the shoulders, which I understand, but if it's a possibility to get a case resolved, a 6-person jury is significantly easier to accommodate than a 12-person jury during these crazy times.
All right, let me address a couple questions then. Here's one that says, assuming that civil juries do begin in January and continue, can you talk about how many trials are currently set in February and March, and what's the likelihood of the trial set in February, March actually going forward as of now? And I'll tell you, while I had a large med mal case today, we were up for hearing on some motions, and it was set in January. It's going to be reset. And they asked me, is March realistic? So go ahead, Bob. I'll let you.
When you say it's realistic, will we be ready to do it? We will. When you say it's realistic, to the extent that the pandemic's going to preclude us from doing it, I don't know that I have any insight. I know this is not what everybody wants to hear. I don't know when the Department of Health is going to turn around and tell us that something like jury selection is just too dangerous to continue to do. I don't know the answer to that. We will be ready to go. If I had a crystal ball and can tell you this is exactly what's going to happen in terms of the health stuff and the pandemic, I'd be happy to answer that, but we will be ready to go. Every day that goes by, it seems like the numbers are getting worse and worse. I'm getting a little bit more pessimistic every day, but we're going to continue to be ready until somebody tells us to cut it out. And Dave, I don't know if you have any thoughts about that.
Well, yeah, I mean, we're gonna try to set them, and as I said earlier, we're going to try to meet every week and give you at least 60 days notice of the likelihood of your trial going. But I'll tell you all in my call, and I'm sure Judge Kleeman's the same way. We're getting backed up. I'm booked almost every week, as it seems, through the summer now, because obviously we haven't had any for the last year. So it's going to be tricky to try to accommodate all those with A, the number of cases, and B, the limited space that we have. Here's another question about jurors.
I'm sorry, Dave, I don't apologize for the interruption, but we have only a handful set in January, and in February, the 8th is a Monday, that's a non-jury week. The 15th is a court holiday, I guess it's President's Day, but we have 3 set on each of the other days. And then beginning in March, we have at least 3, 4, or 5 set every Monday. So, and it's going to continue to go that way, I expect, as we get into April. There's one here with 2, 4, 5 set. So it's starting to get, in terms of what we have booked, January is going to be light, but after January, it starts to get to be a few a day, and then March and April, several a day. So, we're going to get busy if we're allowed to pick juries.
All right, another question about juries is, will cases already planned as a 6-person jury be given priority along with the other criteria mentioned?
It depends when it's set. I've talked to the small claims judges, and we're going to try to get those done. I don't know if they'd be given priority, but if we can do it and it doesn't really affect anything, and we can do 2 at a time. So say in January for instance, we had a jury going and there was a small claims case that was ready that could be done by virtue of a 6-person jury. Under those circumstances, I would talk to the chief about doing more than one at a time, because a 6-person juries, my experience is frequently are done in like a day. So we wouldn't have that problem of them having to report back to the courthouse day after day like you would, in a week-long trial. But after that, going forward into February, March, things like that, when we have 3, 4, I don't know that they would be given priority, but I would certainly take a look at it. If we could accommodate it, I know small claims cases have got to go as well. And if we could get it done safely, I'd like to do 2. I'd like to do 3 at a time if it could be done safely. So we'll do our best, but I can't tell you that it would be given priority. We'll take a look at that along with everything else.
All right, here's a question about the jury commission. Does the jury commission ask jurors beforehand whether they would be uncomfortable serving, either due to potential health concerns or some sort of a problem wearing a mask because of infringement about personal freedoms, constitutional rights?
Right.
Has the jury commission been involved in doing that yet on the criminal end?
To my knowledge, they have not. We've had some discussions about this among the law division judges. My particular position would be right now that if it's not going to be done, and maybe we should take a look at doing that, it's actually not a bad suggestion, but I would, if there was a trial in front of me, any questions related to COVID, I've told this to some of my colleagues, I would probably be inclined to say those questions have to come from me. And the reason is not that I don't trust anybody, but it can be such a hot button topic with certain people that I think it could be, again, I don't mean to suggest anybody's motives are bad, but it could be used to try to exclude a juror. I mean, the COVID thing can be such a sensitive issue. I probably would ask those questions. And actually, Dave, it's not a bad point. I'm going to make a note. We might want to consider seeing about getting some survey questions out there. So when these folks hit, there's just standard questions that hopefully give you some basis to size that issue up.
All right, and there's a couple more here that we need to answer. Are you doing bench trials by Zoom? The answer to that would be yes. We're happy to do them if everyone agrees and everyone wants to be accommodated. But to date, we have not done them by Zoom. Go ahead.
No, I think that's exactly right. We will. We can do all of it, part of it, some of it. I've done Zoom where we had certain witnesses. And like I said, if you'd told me a year ago I'd be taking an expert witness testimony in a bench trial via Zoom, I never would have believed it, but it went remarkably well. So again, if the parties want to do it that way, I cannot imagine what the problem would be doing it. Our experience with the Zoom process has been really, really positive. So we would be up for that if the parties agree. If there's a disagreement about how we go, I guess we just have to take that one at a time.
All right, here's another question that actually we talked about as a division. Is there any consideration for mandatory pretrial conferences in an effort to try to eliminate some of the cases set for trial?
We've talked about that, and we've talked about trying to encourage it as best we can. I guess again, I don't know that we've hammered this out, but my position would be like mandating it can be a waste of time if the parties aren't interested in doing it. So we haven't mandated it yet. Dave, I don't know if you have any thoughts about that, but my initial reaction was if somebody's not interested in sitting down and pre-trial and isn't motivated to do it, ordering them to do it has been, I don't know. I don't know that I'm persuaded by it, but perhaps I should give that another thought.
Well, our biggest problem with that is, and don't mean to pick on anybody here, but there are certain insurance companies, for example, that simply don't give a settlement authority to their attorneys. So to have someone come in who simply doesn't have settlement authority is really not going to be productive. So I do try to ask both sides on every case, if I remember, if there's a chance to settle the case, let me know, and we'd love to accommodate you. If you can talk to your adjusters, get some reasonable money, we're happy to give you. We do them on Fridays, as you all know. We're doing some in the afternoons now, so we can get more of them in. But it's a great idea to try to get your cases set for pretrial as soon as possible. We're happy to accommodate.
All right. Do you have any other questions, Dave?
There's one question that's not so much towards the COVID or the juries. It's about what procedure do we follow to get a special administrator appointed in order to file a wrongful death lawsuit. I'm not sure that's changed at all. I think it's still the procedure where you have to bring your petition and get a judge to sign the order appointing the special administrator. I know there's a flaw in the statute because the clerk's office typically doesn't want to give you an order without a case number, and you can't get a case number without an administrator. So my best advice would be to try to find one of us, bring your petition to appoint the special administrator, and have somebody sign the order. But Bob, I'm not sure you've done those.
Oh, nothing about the pandemic has changed that. It's not uncommon pre-pandemic for somebody to literally walk to the secretary's window and present a petition and a proposed order so they could file. Whether it's done by email and a phone call now, or if you want to walk over sometime other than the HVAC week, be happy to do it that way. But the pandemic really hasn't changed that in terms of the procedure.
That is all the questions I have. I'm not sure if Mr. Rupp has anything further. Go ahead.
No, I do not. We've been watching the queue together here, and it looks like that has cleared us out.
All right. Well, again, on behalf of all the judges of division, I know Dave feels the same way. I want to thank you all for attending today and your time and attention. And our experience with this Zoom thing, given some trying times, has been real positive, and we all recognize that's due primarily to the hard work of all of you. So again, thank you all for your hard work, and thank you for coming today.
And one last point I'd like to make that Bob mentioned earlier, if you have suggestions from other counties or other jurisdictions that are helping solve some of these problems, we are open to suggestion. We're flying blind just like all of you are and trying to do our best for you guys. So we're here to help. And if you can think of anything you'd like for us to do that might move things along, please let us know. Don't be shy to ask about it.
I agree. Thank you all.
Oh, question came.